Do a search for the Texas TwoStep and you'll get dance tutorials.
This dance is Texas Two-Step.
Quick, slow.
The occasional movie clip.
Gotta do two-step? You bet.
Hey, Slick! In the future, we ever do the Texas Two-Step?
Yes, sir!
And increasingly, explainers on a new legal strategy.
The Texas Two-Step is a legal maneuver that companies use to resolve their mass tort liability.
In 2017, the global paper and building material manufacturer Georgia-Pacific, which is owned by Koch Industries, had a problem.
They were facing a lot of asbestos liability related to some drywall-related products that they made.
More than 60,000 lawsuits, in fact.
If you or a loved one worked at the Georgia-Pacific plant located in Plattsburgh, New York, and have developed mesothelioma or lung cancer, we can help you.
The company was staring down years of costly litigation and potentially billions in awards or settlements. But their lawyers at Jones Day had an idea.
Jones Day helped Georgia-Pacific create an entity called Bestwall. It then took Georgia-Pacific's asbestos liability and put that into Bestwall. Bestwall then filed bankruptcy.
Thus began the first notable use of the Texas Two-Step. But, forgive us, let's take 2 steps back. How exactly does the Two-Step work? And why Texas?
In the late 1980s, Texas lawmakers created a law that allows a business to split in two. The business can then choose how to split its assets and liabilities between those entities as it pleases.
The law was a pro-business attempt to give companies in the state maximum flexibility. It had little to do with bankruptcy, until lawyers waltzed in.
A company will go to Texas and use the divisional merger laws there to create 2 separate entities. One of those entities, the company will place its mass tort liability into. The other will get the remaining assets and other liabilities. The entity that is then facing the asbestos liability is then placed into bankruptcy. That entity then goes through the bankruptcy process while the main company's assets are kept out of reach of the plaintiffs who are now creditors in the bankruptcy.
Ta-da! In 2 simple steps, a company takes all its mass tort liability, and the main company gets to scoot along.
I've talked to plaintiffs' attorneys who say bankruptcy is an okay way to resolve these suits, but in bankruptcy you have to put your assets on the table for creditors to look into and for creditors to pull value out of. In these Texas Two-Step cases, that's not happening because a lot of the assets aren't in the bankruptcy, so they're kind of kept away from the reach of the plaintiffs who are suing the company.
My dad died an excruciating, horrible death that he did not deserve. He never got a chance to see any kind of justice from them.
Plaintiffs are also frustrated because these corporate shells are often funded with a limited amount of money, so they feel like they're not getting access to the entire pie.
But the Two-Step's defenders claim that for plaintiffs, the tactic is a better dancing partner than the alternative, litigating in civil court.
If these lawsuits with tens of thousands of claims were litigated as civil lawsuits across the country, you would see a race into the courthouse where whoever gets there first gets to grab a big jury verdict, and if you're in the end of that line, maybe all that money is exhausted from the company.
In addition to Georgia-Pacific, Jones Day has two-stepped with 3 other clients, including Johnson & Johnson, over tens of thousands of lawsuits claiming its talc-based baby powder causes cancer. Meanwhile, the tactic has gotten the attention of Congress.
This ploy allows large corporations on solid financial footing to shirk responsibility for damage their products have caused and delay paying due compensation for Americans they have hurt.
As corporations, plaintiffs, judges, and even lawmakers wait to see if the two-step is a legitimate use of bankruptcy law, there is one party dancing all the way to the bank.
The two-step has been particularly lucrative for Jones Day, who has billed some of its individual clients tens of millions of dollars for its work on these bankruptcies.